Good morning, Mr. Watson. You may proceed.
This is matter 10213, is that correct?
We've called all three cases together, Mr. Watson, as we frequently do, so that you can argue all three cases at the same time.
Will I be allotted 10 minutes for each one or 10 minutes total?
One of the things that I would ask you to do is not to introduce any extraneous evidence. You can tell me which case you're on.
Okay.
Okay?
No, the question was, is it 10 minutes for each argument or is it 10 minutes total?
We will just see how it goes because we're
Okay.
hearing all three together.
Okay.
I'll make sure that you have adequate time.
Thank you. The matter 10213 is before this court. It concerns the requirement of a justice of the court to provide a hearing in the matter of a application for a waiver of fees. And it also concerns the public records law and the compliance by the defendant. I applied for a affidavit of indigency and waiver of fees in Suffolk Superior Court before Justice Alan Van Gestel. Judge Gestel refused to provide me with a hearing. What basically he did is I sat in the lobby. He reviewed my matter from within the chambers, sent the decision to the clerk's office where I received an order that there should be a partial payment. My argument is that justice of the court is not allowed to deviate from what is the statute. Specifically in Section 27C and 27D, it requires that an individual is given a hearing. At that point, the individual is given an opportunity to argue and exhibit evidence, produce evidence to show their level of indigency, and then a justice of the court makes a decision. Since I was denied a hearing, I argue that the denial of that application is void from the beginning because my due process rights were violated, as the cases I've stated in the brief. Out of judicial economy, this court decides to go straight to the heart of the matter. For the past 3 years, I've tried to exercise my rights under chapter under public records law. With the it's been confirmed with through the documentation of my brief that the Department of Public Records informed the defendant that I was entitled to access and to view and inspect and possibly copy records from the Boston Police Department. For the past 3+ years, they have refused. They may argue that they've satisfied my request by sending me an email with regulations, but again, that violates the First Amendment rights as determined by the U.S. Supreme Court. The U.S. Supreme Court has stated in various cases that are in the brief that an individual, the public, and the press are entitled to review, inspect physically documents of a public agency as well as courts. That is basically to enforce the Fourth Amendment's right against abuse of government and to ensure the integrity of the government. The fact that they've emailed me any correspondence still doesn't satisfy the requirements of the public records law. So I would argue that either this court would require Suffolk Superior Court and Justice Van Gestel to provide me a hearing as required by 27C and 27D, or go to the heart of the matter and order the defendants to provide me access to the records that I requested, and that was supported by the Department of Public Records.
Thank you, Mr. Watson.
Sit down now.
No, you can.
Okay.
I thought you had addressed two cases, both the public.
There's a total of 3.
Okay.
Okay.
And then you can just do the last one. Thank you.
In the matter of 10324, it's before this court concerning the jurisdiction of the housing court, the conspiracy of the violation of my rights, the Equal Protection Clause and the Due Process Clause of the 5th and 14th Amendment, as well as the mootness of an injunction that had already been denied and action has been taken. In the housing court, First Justice Winnick, I appeared before First Justice Winnick concerning injunction related to a dispute of a house, my grandmother's house. At the hearing, Justice Winnick violated the Mass Civil Rights Act, Chapter 12, Section 11I. In the hearing, he he issued a statement that the house was the property ownership of the defendant and that I was required to vacate the property, or within 48 hours, he would evict me, and whatever the defendant desired to do with my property, he could do. Unfortunately, he lacked the jurisdiction. Although it was a residence, as stated in my brief, he exceeded his authority. He didn't have the authority to determine ownership of a property. The statement that he determined ownership of the property, I consider violated the Mass Civil Rights Act because it was an act of intimidation and coercion. There was no way that I intended to vacate the property until I had opportunity to address the ownership of the property. Decision was issued on June 2nd when I was...
Well, which court would determine ownership of the property?
Probate court. The probate court. I initially, it's not divulged in the brief, I initially went to the Suffolk probate court. Unfortunately, as part of the actions I've been subjected to at that court, which will be discussed in the next matter, I was denied and I was referred to the housing court. So the housing court did have the authority to issue an injunction to prevent any further invasion of my privacy. With the actions of Justice Winnick, then he injected issues concerning Fourth Amendment rights to invasion of privacy and illegal seizure of my property. I filed a notice of appeal on June 8th, as well as an affidavit of indigency for the waiver of the filing fee for the court tape and for the transcription. The clerk's office refused to act on it. I waited a week and they still hadn't taken action on it, so I approached them again. This time their action was to deny it and send it before Justice Winnick, who again refused to take an action on it. The argument can be made that the single justice did not err in denying my initial complaint of this matter because I was unable to create a record. What has been a common tactic of oppression against me by different courts and clerks and justices of the Commonwealth is to deny me access to court records, which makes me unable to create a record to support any argument I have in any court, specifically this court. Yes, in the brief that I filed, I requested that this court order the housing court to comply with Rule 9 and assemble the record to the appeals court. I spoke to the Chief Justice of that court. I believe his name is Chief Justice Lewis. I may be mistaken, but the documentation is in the brief, as well as Justice Stevens, the Chief Justice of the housing court. In each instance, the record was never assembled. Then allegedly it was assembled and forwarded to the appeals court, and I discovered it a month later. But the integrity of the court, the clerk's office, and the housing court's insistence that they notify me is questionable considering the documented correspondence I have with the Chief Justice of the housing court. My constitutional rights are being violated. And again, I will argue, if you look at cases such as City of Cleburne versus Cleburne, and most importantly, Willowbrook versus Olick, this is a planned conspiracy to violate my constitutional rights because of the opposition I've given to some of the discrimination that the Commonwealth has against men, and then my opposition to their actions. I would argue that this matter is not moot because the issues still remain that the improprieties of the Chief Justice Winnick and as well as the clerk's office of the housing court will need to be addressed. The conspiracy that I argue exists against me should still be addressed, as well as the illegal seizure, theft, conversion, and destruction of my property. The issue is still not resolved because I've been unable to take it to the appeals court to address the issues and the offenses that were committed against me. So I'd argue there's not moot. The Supreme Court this court has already stated that an issue is not moot if a party continues to have a grievance, and my grievance continues to exist.
Thank you, Mr. Watson.
And should I do the last one?
Which one would that be?
10286. I would suggest that
I thought you had 10286 is which one?
Watson versus Walker.
Oh, that's the Walker one.
I would argue that we'll request that one is allowed to wait because there are multiple issues involved in that matter.
Allowed to wait?
I thought the other parties would argue, and then I would argue, or you just want me to continue?
Just continue, thank you.
The matter of 10286 concerns a custody dispute in the Suffolk Probate Court, originally presided over by Justice Elaine Moriarty. The opposing counsel for the state respondents argues that the matter is moot, and that was the decision given by the single justice. I would argue for several reasons that it is not moot. First of all is that the entire proceedings of docket 810, if you will, are void ab initio, because the simple fact that the entire proceedings were based on the issuance of a restraining order of Dorchester District Court that was improperly issued in violation of due process rights, and that matter is before this court. It just hasn't been decided for at this time. Second, I would say that the actions of the first Justice Elaine Moriarty, as well as the Registrar's Office, again would show that there's a violation of my due process rights as well as equal protection rights under the 14th Amendment. The other issue is the constitutionality of the hearing of July 1st, 2004. The court never notified me. That was proving with documentations in the transcripts of February of 2004 and April of 2004. In each hearing, I requested Justice Moriarty for a hearing date. She stated that she would consider it. I received correspondence in response to a motion that I filed that I read to say August 1st, 2004. Now, in the hearings in February 2004 and April of 2004, I specifically requested Judge Murray to take in consideration that her orders being issued in such a scribbled manner they were undecipherable. So the hearing was held on July 1st, 2004. At the hearing, the opposing party's counsel, respondent Mitchell, perjured herself and stated that I had been notified, and if a review of the transcript, you will note that even at that time, Justice Moriarty said, "I'm surprised that he's never missed a hearing." At that moment, she should have continued the hearing, requested that myself, the plaintiff, explain why I failed to appear at the hearing, or the matter was dismissed for lack of prosecution. At that point, I filed a timely notice of appeal. That was July of 2004. In violation of my constitutional due rights to process, constitutional rights to due process, I didn't receive the appeals. The probate court did not forward the record to the appeals court for more than 18 months. It didn't go out until January of 2006, and that was after I filed a complaint in the U.S. federal court, and that was despite the fact that I filed several complaints and requests for assistance to Respondent Ianella, the chief register of the probate court, as well as to Justice Moriarty. I would argue that when the matter finally went before the appeals court, I was never granted relief in that matter, because again, a review of that decision would say that first of all, they failed to answer any of the matters of relief that I requested, other than the constitutionality of the hearing of July 1st, 2004. In their decision concerning the matter of July 1st, 2004, their remarks and their actions were perjury, were acts of perjury and fraud. They specifically said I was notified. They referred to the hearing dates on February 2004 and April 2004, but again, the transcripts were before them as they were before this court. I was never notified of the hearing, and their actions are in direct contrast to the decision in Cooper versus Wilkins, which was by coincidence roughly a month or so later in July. The circumstances in Cooper is very similar to my circumstances in that one party initiated a complaint. At some point, the court failed to notify him of a hearing. He didn't appear, and the matter was dismissed. Now, the appeals court said that his due process rights were denied because he failed to be notified. I would argue also that not only because of the restraining order out of Dorchester District Court, the entire proceeding should be violated. But the decisions throughout the proceedings of Justice Moriarty can only be considered arbitrary since she's never issued any specific writings. At the outset of the matter, the opposing party made an accusation that she was concerned about my daughter because she claimed I was an alcoholic and heroin addict, which I insisted to Judge Moriarty, I won't take an aspirin, but there's only one way to prove this because you don't know the parties. Test us both. If you don't test us now, I request that you order a test at a test lab, but you use the hair follicle method as opposed to urine because too many people claim that they can beat the urine test. Before the end of the hearing, I asked the judge would she order the drug test, and she said yes. I said, well, what does that do about my visitation? She said, well, your visitation was based on your results from the drug test. My argument to the judge was, well, what happens if her drug test fails? At which point she did nothing. So there's no standard of evidence. You don't know what standard of evidence or what rationale she had for refusing to make conditions if the biological mother failed the drug test. After a month and a half of refusing to take the test, the mother finally takes the test and fails. And then she fails on multiple occasions. Throughout these proceedings, the other party has purged itself over a dozen times. It would be rather hypocritical of this court or any court of the Commonwealth to insist that, that lying strikes at the very heart of any proceeding and is counterproductive and the antithesis of everything that the judiciary stands for, but then refuses to act on the justice who allows one party to commit over a dozen acts of perjury, as well as the issues concerning contempt that were in the court. These are, again, documented by an impartial third party, the Boston Police Department. Whenever she failed to comply with the visitation order, I made a complaint and received it. I filed a complaint, went to court in October 2003. Again, Judge Moriarty dismissed the matter with no specific written findings, and she had documentation of the police reports, as well as an admission by the opposing party that she did it. And this has been ongoing. Presently, as of the decision in February of 2004, I've been denied the right to file motions without prior approval. That violates my First Amendment rights to access to the court and petition the government. Every motion from May of 2003 to February of 2004 could not be considered frivolous. In fact, many of them were supported by third parties. One of the complaints that was made to the court is a restraining order to prevent the biological mother from taking my daughter to her maternal grandmother's because the mother's maternal uncle had pedophile tendencies and was a sexual deviant, making offenses.
Mr. Watson, this is not a trial court, and I would ask you not to make very serious allegations against people who are not here to defend themselves. You can refer to the materials in your brief, but not make allegations with people who are not here to defend themselves.
Well, I would argue, judges, that these statements are all contained in the brief. It was argued that in January 2004, I asked for the restraining order against the biological mother, and in that document, I didn't name the name of the uncle, the biological uncle. I stated that it was on record it was an admission by the biological mother previously that it was true.
Okay.
And so and therefore, again, this would bring up the issue of the violation of my due process rights and equal protection clause. The U.S. Supreme Court has determined that if the state infringes upon a constitutionally protected right, is a violation of the due process clause. It has stated that it must shock the conscience. I would argue that the actions of the justices and registrar's office in this matter do shock the conscience. They have left my daughter with a mother with a drug dependency who has failed multiple times. When she failed to comply with the drug testing, Justice Moriarty merely told her she didn't have to continue it anymore. She has exposed my daughter to sexual deviance, which is documented in the transcripts. My accusations documented in a motion for restraining order. It was stated in the hearing of February 2004, and it was confirmed by the biological mother's statement in a hearing in Dorchester District Court. Now, some might say that might not shock the conscience, but I would argue that it is, because in one matter, I believe is Glendella versus Gilway, the U.S. Supreme Court determined the fact that a police department threatened an 11-year-old in order to determine the drug use, get information on the drug use of parents. They determined that was shocking behavior because it interfered with the parent-child relationship and bond, which is basically the core of our society. And so therefore I would argue my ordeal, my situation should be no less shocking. But finally, I would like to say the other issue that should be remanded back to the probate court to address is my motion that the appeals court failed to address, is my motion for appointment of counsel.
And I know that your time is up, Mr. Watson, and we will read the written submissions, as you know.
Yes.
Thank you, Mr.
Thank you.
Watson. Let me explain how I'm going to proceed. I'm going to call each case by number and ask counsel who are present whether they wish to address the court or would just rely on their brief. In the matter of SJC-10286, Watson against Shelley Walker, Ms. Balakrishna, do you wish to submit on brief?
If possible,
I don't believe there are any questions. Thank you, Ms. Balakrishna. In the matter of SJC-10324, Watson against Kevin McClerkin, I don't believe, is a counsel here representing? Okay. Do you wish to submit on brief? Okay. Thank you. And in the matter of SJC-10213, Watson against the Boston Police Department, Ms. Beauchene, if I pronounced it correctly, Beauchene or Beauchene? Beauchene. Do you wish to submit on brief?
submit on the brief on the matters I was in the brief, but if the court would like me to address the public records that Mr. Watson spoke about, I can. Or if the court finds it not relevant as I submit that it is, then we'll rest.
I don't think that there are any questions. Thank you, Ms. Beauchene. Mr. Watson, before we retire, many of the occasions in which you have come to this court, you have sought relief under General Laws Chapter 211, Section 3, or in the nature of asking us to order something mandamus or certiorari. The relief that you seek in each of those multiple cases is what we call extraordinary. It's very unusual and rare that the court will grant that relief. As a general matter, in most of our cases, when there is a petition such as the many that you have filed, we do grant oral argument, but we are not required to do so. And I simply want to put you on notice that the court cannot be taking under consideration and granting hearings on repeated attempts to invoke the extraordinary power of this court unless there is a basis in which to do it. And so we will take these matters under consideration. We will issue orders in due course after we've reviewed all of the material. But you should know that if there are multiple further petitions, the court may have to view those in a different circumstance.
Do I get to respond to that? Or?
No, I'm simply informing you.
All right, thank you.
Thank you, Mr. Watson.